Education.
Yeah, D. This is Mike. How you doing this morning?
Great.
Okay. Are you ready to go on the McKenzie case?
I am.
All right. Excuse me. I assume no TA or Medicaid?
No.
Okay. And it looks like we may have an emancipation issue.
Yeah, I only have one child eligible. And actually, the note on diary says that she didn't return the 691, and they're going to end that one, as has his 18th birthday in October. So this might be a short hearing. I don't know.
All right. Well, let's see what we can find.
Okay.
D.
Yes.
Please hang up. I'll call you right back.
Okay. Office.
Yes, I'll speak to Sandra Hessenflow, please.
She's not in yet. Do you want to leave your name and number?
Yes, ma'am. My name's Mike Dyer. I'm a child support hearing officer for the state of Missouri.
How do you spell your last name?
D-Y-E-R.
Okay.
Ms. Hessenflow I have as being the attorney of record for Carletha Gaston in an administrative child support modification case with Michael McKenzie. Hearing set for 8:30 this morning.
Okay. Let me try to get her lights on, but let me see if she's out there.
Okay.
Hello?
Mm-hmm.
Yeah, I was on the other line holding for you.
Are you? Okay.
Yeah, there's a guy running around your office.
All right.
Had me on hold. And
All right.
hung up.
Well, sorry about that. Hello?
Hello?
Yes, you still there?
Yes, I sure am.
Okay, and I assume I'm talking to Miss Hessenflow.
Yes, you sure are.
Okay, and Miss Gaston's there with you?
No, she is not.
Okay, do you want me to call her, or is she going to be participating?
Neither one. Mr. McKenzie has been served with our counter motions. We filed some counter petitions and a motion to transfer to the circuit court.
Okay.
Have my pleadings there?
Yes, I do.
Oh, okay.
And I saw those, and I was curious, have you all got any kind of time frame set up on this?
Yes. Mr. McKenzie, the judges had already set one case management conference, and I tried to serve Mr. McKenzie at the address on the paperwork you sent.
Mm-hmm.
And they said that he had moved about 5 months ago. So I was hoping if he calls in, I can get his new address and serve him, because the judge went ahead and scheduled it out for another case management in September. I mean, I don't know how you feel, but it seems kind of silly not to do it all at once.
Well, yeah, it certainly is my feeling, and I understand. The 3 of the 4 kids looks like they're pretty close to emancipation, and I noticed that the agency didn't figure that in.
Yes, and one of them is emancipated, 2 are in college, and 1 is still in high school.
Okay.
And the 2 addresses I have were the 3743 Flora, and when we tried to serve it there, they gave us this new address, Country Club Hills, Illinois, and when we went there, they said he'd moved out of there about 5 months ago. So I didn't know if your tech has heard from him, or if he has a more recent address. If he's basically gone and is not going to proceed anymore, then she says she'll just dismiss her part of the case until he rematerializes. If he does, call in, or we can find out where he is or what's going on. He has never been served with the counter petitions because the address information I have isn't up to date.
Okay. Well, if you hold on, I'll see if I can get him online.
That'd be great. Thank you.
Hello?
Yes, I'd like to speak to Michael McKenzie, please.
This is he?
Mr. McKenzie, my name's Mike Dyer. I'm the Child Support Hearing Officer for the state of Missouri. I'm calling in regard to the hearing with Carletha Gaston this morning. Are you ready to go ahead, sir?
Yes, I am.
All right, please hold. Mr. McKenzie?
Yes.
Ms. Hessenflow?
Yes, I'm here.
All right. And Ms. Hessenflow, am I pronouncing your last name correctly?
Yes, you sure are.
All right. If y'all will hold on, I'll see if I can get the agency technician, D. Hayes, online.
All right. This is Dee.
Yeah, D, I've got him online.
Okay.
Ms. Hayes?
Yes.
Ms. Hessenflow?
Yes.
And Mr. McKenzie?
Yes.
All right. Mr. McKenzie, Deanna Wilson Hayes is going to be the agency technician on the case this morning. And I understand what we're talking about this morning is what child support should be for you and Miss Gaston's 4 children. Is that your understanding, Mr. McKenzie?
No. Right. I was putting in a review because of the fact that I was never served the original establishment order, and it was never filed with a true return copy of the return service when it's filed. So I believe that the order that has been used to garnish my wages for the last 4 years has been a null and void order because it was never filed with the court.
Well, sir,
I was denied due process of law by the fact that I was never properly served. It was never served at my residence, which was 8609 East 87th Street.
If I can respond to that, Mr. McKenzie, there are some pleadings pending that you're not aware of because we haven't been able to serve you this time. On the information packet you provided for the hearing today, it says you live at 3733 Flora, and you were looking for Pro Electric. I contacted both of them, and they gave me a new address at Country Club Hills, Illinois, so I tried to serve you with our packet of information and my discovery request there, and that was also returned and said that you had moved.
No, so I've served you, spoken to you regarding the child support from my union.
Right.
The $30,000. So we've been in communication.
Okay, but I don't have you've never given me the address that I have.
You've mailed me information to my address here in Country that I have from
Well, then the person who answered your door said you hadn't lived there for 5 months. I have been sending mail to the address you gave me, but I couldn't serve you at that address. When the sheriff came out there in Pulaski County, Illinois.
There's no point in living in Cook County, Illinois.
Well, the address you gave me was 17963 Pulaski Road, number 304, Country Club Hills, Illinois, 60478. Is that still your address?
No, there was the correction that was made. I've received information from you. I have information from Ms. Wilson with that, but it was delivered to me, which has 17963 Pulaski Road, apartment 304 that I received. So. Well,
where are we supposed to get information to you? Because if you have an objection that you want to raise, and Mr. Dyer may disagree with me, but that's not what's pending in front of the agency today. That's probably better addressed in the circuit court proceeding if you want to raise a motion to object to.
That is how I'm proceeding, is that I was denied due process of law on the onset of this whole establishment order that was set in place on July of 2002.
Okay, well, that would be a responsive pleading you could file in response.
No, that is my argument. That is my standing. That I'm proceeding with.
Mr.
I'm sorry.
Mr. McKenzie, the agency is looking to modify your all's divorce decree.
Okay. Well,
and I understand that you say that you weren't properly served with that decree. I mean, there was an administrative order then in 2002, just shortly after the administrative order was issued, your all's decree was issued.
But the decree was based on allowing the order that had been entered to remain in effect. So I feel
that very well may be, sir, but I can't do anything about that right now. I've got a Jackson County order that says you're required to pay $165 a month.
And this is a preliminary order because I plan on pursuing Trump Elbow in Jackson County Court. So at this point, all I really would like to have is my 18 exhibits entered into the record, and I have nothing further of a defense to or argument to make. It's just I've properly served every party involved in this hearing, and of the 18 exhibits, everyone has been properly served, and I would just like those exhibits admitted into the record.
Actually, Mr. McKenzie, I sent you a discovery request, and I asked for copies of those documents, and also, since obviously you're no longer working at Pro Electric in Kansas City, Kansas, if you live in another state, I had asked for your updated pay stubs. You said that you did receive some of my mail. Did you receive them?
No, I haven't received any. Currently, I'm unemployed. I have not worked in the state of Missouri since December 2005.
Right, I understand that you've moved.
All right.
Okay.
Folks, and, Mr. McKenzie, I believe I have indicated that I can't do anything about the validity of the existing order.
Okay.
And that's something you're going to have to take up in court. And, Ms. Hessenflow, I also understand that you've got a court action proceeding.
That is correct.
And you're looking at a status conference or something like that in September, is that correct?
That's correct. And again, Mr. McKenzie hasn't received those papers. I still haven't heard an updated address. Hopefully I can get that before we get off the phone.
All right. Well, I guess my question then would be, folks, the only way that the original order is going to be affected in any way is to go back to Jackson County and get it done there. So I guess my question is, does either side object to us just removing this from the Administrative Hearings Unit docket and let Jackson County take care of it?
No, I would like a hearing to be proceeded with, finding of fact to be rendered, finding a written order, conclusion of finding of fact rendered from this hearing. I've waited since December 2005 to obtain this hearing, so I would not like nothing to have come from this hearing after waiting so long. So I would like this hearing to be proceeded on with and a finding of fact written order containing finding of fact and conclusion of law entered from this hearing.
Right. And Mr. McKenzie, you understand that any order I write will be canceled out by the pending Jackson County.
That's fine.
All right.
Your Honor, my objection to that is that the information on the financial informational statement is obviously outdated and incorrect. If the technician enters that information into the record, any findings you make based upon that are incorrect. I have a discovery request asking for, obviously, his current information. If he's not working, it asks why he left his most recent job, all of that. So I don't have any of the information, updated information from Mr. McKenzie upon which I could even prepare for an administrative hearing. He simply hasn't provided any updated information.
There's no information to provide since I've been unemployed.
All right.
So there's no updated information to provide. There's no income to calculate. Therefore, no new additional finding to conclude.
Right. Well, I did contact Pro Electric, and they indicated to me they did respond to my request that the information you put down is highly incorrect, that you earn far more than $2,300 a month there. So I certainly can fax the information I got from Pro Electric. With still covering 3 children, your support would go up, not down, which is why I sent you a request for your accurate information. I'm going to request, first of all, the judge has already consolidated the administrative proceeding pursuant to my motion into the circuit court cause of action. Mr. McKenzie hasn't seen that motion.
Hessenflow.
Yes.
Said have you got an order consolidating the cases?
I do have the judge set that for the case management. She wouldn't have done that if she hadn't already taken jurisdiction over it. But again, we didn't have that court date because Mr. McKenzie couldn't be served at either of the addresses that I had. So, I mean, certainly if you want to make a proceeding, if you want to have an administrative hearing, I think that's a waste of time, but we can do that. But before we do that, at a very minimum, Mr. McKenzie needs to respond to my discovery with regard to his wages, his accurate income, why he left his most recent job. And again, I've heard him tell us that the addresses we have are incorrect, but I still haven't heard a correct address where he wants me to send this information.
All right, well, that is the purpose of the hearing, is to try to get the most up-to-date information available from the parties. And Mr. McKenzie does have a right to an administrative hearing, so we will proceed with the hearing this morning with the understanding that anything I decide will most likely be canceled out very shortly after it's issued. And Ms. Hessenflow, if you've got an order consolidating the cases, that certainly takes away my jurisdiction. But I don't have a copy of that order consolidated.
I don't have anything other than the judge setting it for case management, which obviously the court wouldn't do unless she was going to have jurisdiction. But I can...
Well, she's always has jurisdiction. It's
right.
The question of whether or not we can proceed or not. You know, if I had an order saying that it had been consolidated, then that would be the end of it. But unless you've got something to that effect, I think we probably ought to proceed this morning.
Okay. And there may very well be one in the court file. Again, I normally wouldn't get that until case management. I will check, and if the court did intend to consolidate it, if you want to take it under advisement today, I can let the court know that you went forward with the administrative hearing, and does she want to wait and have me do a judicial review and then consolidate, or if she wants to go ahead and issue a written order. Again, she normally would not have done that. I can certainly get that to you before you go to the trouble of writing an opinion if the judge has accepted jurisdiction.
I don't know how any type of proceedings could proceed without me being properly served and made a part of the proceeding. So if you haven't served me, I don't see any. I know the court retains jurisdiction from the divorce decree, but any actions that would alter the standing divorce decree, child support order could not be done without me first being served. And since you have been unable for whatever reason to serve me, I don't see how any type of administrative hearing or any effect could have about.
Mr. McKenzie, you've obviously been served with today's actions.
Yes, I have. So I know that.
And we are going to proceed with today's actions.
Okay.
Just that if the court has indeed consolidated these cases, then I have lost jurisdiction. The reason we're proceeding this morning is because I simply don't have any not that I'm doubting Ms. Hessenflow's word, I just need something verifying that the court has indeed consolidated these cases.
Okay. I had a question in that manner. If, in fact, the court consolidates after today's hearing, does that have any effect since it was done after you had the hearing as far as having jurisdiction?
Well, it would depend on the date of the consolidation.
Okay, but if it's done after today's date, what effect would that have on us?
Well, then I would still go ahead and issue a decision which will and be canceled out by any action by Jackson County Circuit.
And then I won't have to worry about serving Mr. McKenzie because he is and has properly been served in the administrative proceeding. So if I file a judicial review, I just have to send that in the mail. I don't have to serve him personally with that, and then it can be consolidated into the things that are already pending. So there is a benefit to me in going forward today with, if you're going to issue an administrative order, then I can file a judicial review and send it to whatever address he gives us today, and I don't have to worry about serving him.
All right.
I'd prefer not to go that route. I'd prefer he be served and know what's going on up front, but if he wants to do it that way, we can.
All right. That's what we'll do. And folks, generally speaking, I give parties an opportunity for a settlement conference. Is there any point in that this morning?
No, there's
no.
Right, I didn't think so. All right, my next question then would be, I understand both sides have requested the administrative hearing. Ms. Hayes, it looks like the review was at the request of Ms. Gaston, is that correct?
No, well, she did not return her forms on time, so the NCP turned around and requested them on.
All right, I see. So then, but I understand both parties have requested hearings, is that correct?
That's correct.
Okay. Well, then this question is for both of you, subject to any evidence that's offered this morning, again with the understanding that we are going to be leaving the hearing record open to determine whether or not this matter is being consolidated. and any additional documentation that the parties might want to submit after the hearing. Would either side have an objection to the agency documents being entered into evidence?
Yes, I have an objection to the agency documents being introduced. Apparently, Mr. McKenzie says he has attached 18 exhibits. Are those part of the agency packet?
Well, let's go through the packet right quick so everybody knows what I'm looking at.
I have his financial and informational statement, and a copy of the order and the proposed amended child support amount.
I have, Ms. Hessenflow, I have your client's request for an administrative hearing. Then I have Mr. McKenzie's request with administrative hearing. With respondents list for requested administrative hearing on motion to modify.
I do not have that.
That was included in part of my hearing, as part of my hearing packet. Ms. Hayes, did you not send that to?
Yes, it should be right behind Michael's hearing request. It's 3 pages.
And then I have his list of exhibits that runs, let's see. Through those. Possibly 1 through,
I just have the documents that were sent to Ms. Gaston.
That's exactly what we're talking
about. That same packet that I sent.
Okay, well, I sent again, a discovery request to Mr. McKenzie at the address on here requesting anything that he was going to utilize in the hearing and information on his last job after I contacted Pro Electric.
All right.
Well,
that's right, folks. Ms. Hayes, when did you send the hearing packet to the parties?
On January 30th.
Okay, I wasn't her lawyer then.
Okay, so it's possible then that Ms. Gaston has not provided you with that documentation.
I received your hearing request on January 30th with your name and address and phone number.
Right.
So I sent that to the address on January 30th.
Hang on, let me get my hearing request. Well, I'm going, my file is 2 volumes, so I've got quite a bit. I may very well have it.
Are you at 1102?
Not seeing it here.
Are you at 1102 Grand?
Yes, I am.
The address I sent the hearing packet to, ma'am.
Okay. In any event, why don't you then go through what the documents are, and I'll let you know whether or not I object one at a time.
Well, let's wait till we're on the record.
I believe I would object to that because the time has expired for any objections since I...
No, sir, we're doing the hearing. Parties can object to anything during the hearing.
Okay, well...
And then I'll make a ruling on the objections.
Okay. Well, I was understanding that they had 30 days after being served to raise any objection to any documents, and I served Ms. Gaston back in December of 2006.
I don't know anything. I mean, he may have done since things that still wouldn't alleviate any evidentiary objections I would have, such as foundation or hearsay.
All right. In that case, folks, what we're going to do is go on the record. I'll have Ms. Hayes present the agency's hearing packet, and we can handle any objections at that time. And then we'll proceed with the hearing to obtain information regarding both parties' current financial situations so that I can make a decision one way or the other, dependent upon whether or not this case has been consolidated.
Okay.
So with that, we're going to go on the record now. Administrative hearing will now come to order. My name is Mike Dyer. I'm an attorney licensed practice law in the state of Missouri, employed by Division of Legal Services, Missouri Department of Social Services. I've been designated by the Department Director to conduct child support and administrative hearings. Today's hearing number is 4704-MOJ-FY07. And it relates to an action initiated by Missouri Family Support Division to modify a child support order originally filed or as issued by the Jackson County Circuit Court. in September of 2002. The issue determined in this hearing is whether or not there's been a change in the party's circumstances so substantial and continuing to justify a modification in this matter. Based on the agency's request for an administrative hearing review from Respondent Michael McKenzie, the agency issued a motion for modification on August 3rd, 2006, indicating that child support should be modified to $918 per month for the 4 children of this order. Based on the agency's motions, both parties requested administrative hearing, which is being provided this morning in accordance with Section 536 of revised statutes of Missouri. This hearing is being held by way of a telephone conference call originating from the Broadway State Office Building in Jefferson City, Missouri. Today's date is July 16, 2007, and this hearing was convened approximately 8:51 a.m. It is being recorded. In addition to myself, the participants in this hearing are as follows: Deanna Wilson Hayes, agency technician; Sandra Hessenflow, attorney for petitioner Carlotta Gaston; and respondent Michael McKenzie. Again, folks, this hearing is designed to be informal in nature, and evidentiary rules contained Section 536.070 of the revised statutes of Missouri will be followed. Evidence from this morning's hearing will be received, recorded, and considered, and a written decision issued and mailed to the parties. Any parent aggrieved by this final agency decision will have the right to file a petition for judicial review in the appropriate circuit court. All right, this time I'll go ahead and swear in the witnesses. I understand that Deanna Wilson Hayes and Michael McKenzie will be testifying. Would each of you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, Ms. Wilson Hayes?
Yes, I do.
Mr. McKenzie?
Yes, I do.
The record reflects that Michael McKenzie and Deanna Wilson Hayes are duly sworn. With that, Ms. Hayes, as the agency technician, please go ahead with the presentation of the agency documentation at this time.
Okay, Mike, you want me to explain what's in the hearing packet?
Yes, do your,
Okay.
yeah, please go ahead with the presentation of the documentation contained in the hearing packet.
Okay. The first page is the CP's attorney, Sandra Hessenflow's request for a hearing. Then we have Michael McKenzie's request for a hearing. Following that is Respondent's Exhibits list for requested administrative hearing, which is 3 pages.
Which I would want to inquire whether, I'm not sure if that's the exact documents, because the documents that I received from you concerning some of my exhibits, like the Exhibit 1, contained a second page that was not included in your document. It either was oversighted or left out by some other means. But my document that I submitted contained, which was the arrangement, withholding agreement that I entered on June 24, 2002. It had a second page which had my address, mailing address on the second page, and that second page was excluded or was not included in the hearing packet that I received. I wanted to make that note.
Yes, I don't have that second page, sir, in my hearing packet either.
But on my documents that I submitted directly to the administrative hearing section, it did include. So I would like to make that noted on the record that my exhibit for that, for Exhibit 1, which I submitted, which was included in her packet, excluded the second page of my Exhibit 1, which was on the back page. It was a front and back page exhibit.
Okay. Okay.
All right, let me stop you there. I'm sorry. The first 2 things that you mentioned in the packet, I have no objection to them being admitted. You said Respondent's Exhibit list. Is that just a list of the exhibits, or is that actually incorporate the exhibits themselves?
It's like number 1 is telling you that number 1 is the Exhibit 1.
Okay, so it's just a list of the exhibits.
Correct.
Well, there, in my copy, there is his list, or Mr. McKenzie's list. It lists 20 different points. But the exhibits I have, Respondent's exhibits only run through Exhibit 18.
Okay, well, if it's a list of his exhibits, I don't have any problem to that being introduced.
Okay.
And then, what was the next thing in the packet?
I'm sorry, Mr. McKenzie, were you about to say something, sir?
Yes, some of the exhibits that, the reason that you have 20, number 20, and some of the exhibits refer to the same exhibit twice. So.
Okay, all right. And Mr. McKenzie, I assume you have no objection to your own documents being entered into evidence?
No, I wish all 18 exhibits to be admitted.
All right, and Ms. Hessen-Flo, you indicated you had no objection to that either, is that
The
correct?
list of exhibits, no.
Okay, the list. All right.
I think she said the next thing in the packet was a 3-page list. I don't have any problems to that being admitted.
Okay. All right, and then in my packet, Ms. Wilson-Hayes, the next documentation I have after the 3-page list is the 18 exhibits. Is that what's contained in your packet?
That is correct.
Okay, let's go through them. What's the first one?
It is an immediate income withholding alternative arrangement agreement.
No objection.
Okay. Certification circuit court exhibit.
No objection. That's probably on the underlying administrative order?
I believe so.
Okay.
Copy of the administrative order filed on July 10th, 2002.
No objection.
Okay. Entry of appearance by Mr. McKenzie.
No objection.
Entry of appearance by Ms. Gaston.
No objection.
Affidavit of mailing says that the documentation was mailed to Mr. McKenzie on July 3rd, 2002.
No objection.
Same document for Ms. Gaston.
No objection.
Notice and finding financial responsibility.
Is that for the current case or the previous one?
That is, it looks like it was,
The first. It was back in 2002.
yeah, August.
Objection.
Okay. That includes the Form 14 calculation. The next, Exhibit 9 is petition for order of protection.
No objection. I think I have that in the old divorce case file here.
That's 4 pages. Respondent's Exhibit 10, Respondent's Affidavit and Issues List for Requested Administrative Hearing on Motion to Modify.
I don't know what that is.
Well,
That's an affidavit I submitted stating the facts that I was basing my request for hearing, the issues that I was stating for to be used as far as what my basis of my argument was for this hearing. My
I would
testimony
object entry of a list of arguments. He can obviously testify and make any arguments that he
well,
wants to the record.
it's a written affidavit that I submitted. I have a right to submit an affidavit in this hearing that I requested.
Well, I would object. This is a live hearing. I would object to him testifying by affidavit. He's present and available and can testify on his own.
all right, well, I'm going to have Mr. McKenzie go ahead and offer any testimony that he has this morning. And then after the hearing, Ms. Hessen-Flo, I'll send you a copy of Respondent's Exhibit 10, and you can offer any written objection you might have to that document.
Okay. What's next?
Respondent's Exhibit 11,
Okay. I mean, what is it?
Income and Expense Statement of Respondent.
May I inquire of the respondent regarding that document?
You'll certainly be given an opportunity to here shortly.
Okay. Well, is that an old one from 2002 or a current one?
Looks like
2002.
2002. Is that what you said, Ms. Hayes?
Objection. Objection.
All right. Next document, Respondent's Exhibit 12, is the R.F. Fisher Electric Company, dated pay period May 20th through May 26th, 2002.
No objection. Is that when he was earning, what, 26 an hour?
Pay rate $25.90.
Yeah, I have that from the underlying divorce.
Okay, next document I have is from the Bank of America, indicating, looks like it's dated April 4th, 2002. P&I, county taxes, hazard insurance, overshort spread, total payment of $654.43.
Okay, well, I don't know what relevance that has.
I was establishing my residency and that I was staying in and the children were staying at the time that the child support order was entered. Both myself and petitioner were staying at that residence along with all 4 children.
I have 3 objections. The first one is a lack of foundation. I'm assuming there's not an affidavit of records custodian attached. My second one is relevancy of a 2002 document on the issues of modification in 2007. And my third objection, well, I guess those first two will do it.
All right. Mr. McKenzie, again, we are addressing what child support should be at this time. And I understand it's probably going towards the argument about the original order was invalid. Is that correct?
Yes.
All right. Well, I'm going to go ahead and overrule Ms. Hessenflow's objection then regarding Respondents Exhibit 13. But, again, I am only considering what current child support should be at this point.
Okay.
All right. The next document I have is copies of checks. Looks like there's
From what time?
20.
I think it's from 2002, Mike.
Okay. Yeah, there's 2002, 2002, 2001, 2001, 2002, 2001.
My objections would be the same, relevancy to canceled checks from 2001 to a 2007 proceeding, and secondly, again, unless they have an affidavit of records custodian, there's a lack of foundation.
All right, again, I'm going to overrule the objection subject to whatever, if any effect they might have on the current support calculations. Next document, Response Exhibit 15, says custodial. It's non-custodial parent redirect notice.
No objection.
All right. 16, two checks dated both July 12th, 02 and August 8th, 02 from Bank of America with the $11.65 listed as the amount paid.
My objection to those, again, would be relevancy, lack of foundation, and also that the detailed payment history report is the best evidence of any child support payments made, and would ask that the hearing officer consider the records of the Family Support Payment Center as to what payments were received and when, rather than checks from Mr. McKenzie, unless he's insinuating that these payments are not listed on the support payment history.
Well, I don't have a support payment history again because it's a modification case.
And just relevance and foundation.
All right. Well, then again, overruled for the same reasons. Next document is a return service from a D. Jones to the Family Support Payment Center. It doesn't have a date on it.
I don't have any objection.
Okay. Next document I have is a repeat of the prior letter, I believe. Respondent's affidavit and issues list for request administrative hearing on motion to modify, 4 pages. Mr. McKenzie, 25 paragraphs.
And again, my objection is that he's present and able to testify in person, and I object to him testifying by affidavit.
All right. Well, and let's see, was that to be included as part of Respondent's Exhibit 18, Mr. McKenzie?
Yes. I'm not sure. I think they probably could have sent additional, because that should have been Exhibit 10, which is the same affidavit.
Well, like I said, it's
duplication. Right. It could have been just a duplication from them sending it in. I didn't provide 2 copies of that same document.
Right. And again, subject to the understanding that Mr. McKenzie is here to testify, the objection is overruled to the extent that what's offered on that document is not included, or is included in Mr. McKenzie's testimony this morning. All right. next document I have is a qualified domestic relations order.
No objection.
All right. Let's see. That would be... appears to be 2 copies of that document in my file. And both are signed by you, Ms. Hessenflow.
Nope, I have no objection.
All right. The next document is a Principal Financial Group printout. It's titled Logout. Indicating that there's an account balance of $8,304.
For who? Ms. McKenzie or Mr.?
Well, it's to Miss Gaston from the and indicating local union number.
Oh, no, I have no objection to that.
All right.
That's part of the Quadro stuff. I'm sorry.
All right. Third and a fourth copy of the qualified domestic relations order.
I think they are distinct in some nature, that the one refers to the annuity and the other refers to the 401k, which are 2 separate accounts that were divided up and totally depleted to pay for what was determined to be past due child support and spousal support payments.
All right. And again, Mr. McKenzie, any objection to those documents being entered into evidence?
No, I have no objection.
All right, and Ms. Hessenflow?
No objection.
All right. The next document I have appears to be dated 11/20/2006 from the Missouri Department of Social Services to Mr. McKenzie. Thank you for providing address information on the non-custodial parent.
I have no objection to that.
All right. Then another principal financial logout sheet indicating account balance of 0.
No objection.
Actually, 2 of those. Now a billing statement dated November 3rd, 2006, indicating past due child support $29,484.78.
No objection.
Mr. McKenzie?
No objections.
All right. Handwritten letter from Mr. McKenzie to Andre L. Clinton, Child Support Enforcement Investigator in Kansas City. The letter appears to have given an address for Miss Gaston that has been blacked out.
No objection.
Okay. The next document, International Brotherhood of Electrical Workers, Local 124, Benefit Trust Office, dated November 13th, 2006, signed by Bill Barbieri.
No objection.
Mr. McKenzie?
No objection.
All right, another logout sheet from Principal, September 26, 2006, other transfer, $6,300, administrative expense, 10 cents. Earnings adjustment, $1,740. Other transfer, $17,501. And other transfer, $1.73.
No objection.
No objection.
All right. And then yet another logout sheet with transfer dates on September 29th, October 19th, and October 31st.
No objection.
No objection.
Okay. Copy of administrative order, case number 02-MC-201872, indicating the support amount of $11.65 for all 4 children.
No objection.
Mr. McKenzie?
No objection.
All right. Summary page, establishment order. List the parties' names, list the children's names, indicates $11.65 a month is due, and health insurance ordered is marked as yes.
No objection.
Okay. A copy of the parties' findings and recommendations, judgment, decree of dissolution of marriage.
Objection.
No objection.
Okay. Looks like a 2-page letter from Ms. Gaston requesting modification review.
Objection.
No objection.
All right. Form 14 calculation indicating $918 a month.
My only objection to that document is it contains the inaccurate income information of Mr. McKenzie.
All right. Mr. McKenzie, any objections, sir?
I object to the fact that it purports to include emancipated children that should have not been included, that were not due child support at that time.
All right, and I assume both y'all are planning on addressing that during the testimonial portion of the hearing. Is that correct?
Yes.
Yes.
All right, we'll go ahead and include that into evidence subject to any testimony offered in that regard during the hearing. The next one is a computer printout screen from the agency indicating how it came up with its calculations.
I have no objection to that.
All right. Again, Mr. McKenzie, I understand you're disagreeing with that, but subject to any testimony, agreeable to enter that into evidence, sir?
Yes.
All right. Next page, child support obligation computation summary. That basically has lots of X's on it and no numbers.
No objection.
Next one, the work number regarding income information on Ms. Gaston.
No objection. She still works at the same place.
All right, Mr. McKenzie.
No objection.
All right. All right. Child status questionnaire regarding Duran.
No objection.
No objection.
Okay. The next one is the same thing for Dion.
No objection.
Objection.
Employment security information screen regarding Ms. Gaston.
No objection.
No objection.
All right. Mr. McKenzie, your financial information statement.
Financial information from...
It looks like right now it says you're unemployed, but you work
right.
your occupation, electrician with the IBEW.
Okay. No objection.
Okay. And Ms. Hessenflow, I assume, any objection to that document?
Other than it doesn't contain any
Current information.
current information, which I'll address during the testimony.
All right. The next document is the agency's motion for modification.
No objection.
Mr. McKenzie.
Objection.
All right. Mr. McKenzie's return service on that motion dated, it looks like he signed for it on June 17th.
Like, I signed for what?
No, that Mr. McKenzie signed
Oh, no.
for service on the motion on June 17th, 2000. All right. And a process server indication to Ms. Gaston, looks like she was served at 12:07 p.m. on January 17th.
No objection.
No objection.
All right. Well, that's the sum total of the documentation that was included in the agency packet.
Right.
Subject to the objections and the rulings we've made to this point on those documents, we'll go ahead and enter those documents into Agency's Exhibit A. All right, with that, Ms. Wilson-Hayes, as agency technician, do you have anything else?
No, thank you.
All right. Ms. Hessenflow, any questions for Ms. Hayes?
No.
All right. Mr. McKenzie, any questions for Ms. Hayes?
No, not at this time.
All right. Ms. Hessenflow, please go ahead with your client's case.
All right. Mr. McKenzie, in your financial information sheet that you completed, you indicated that you were unemployed.
I was laid off by my last employer, which is Pro Electric, on November the 24th of 2005
Okay.
due to lack of work.
And how long had you been working for Pro Electric?
From approximately May of 2004.
And what position did you have before you went to Pro Electric?
I was a journeyman. I've been a journeyman since May of 2002.
Okay. And before that, did you work at KCP&L?
No, I've never worked for KCP&L.
Where was the pension that was seized pursuant to the Quadro?
That pension was through my IBW, which is International Brotherhood of Electrical Worker, Local 124.
And how many years have you been working as an electrician?
Well, approximately, I turned out in 2002 as a journeyman, but I went through a 5-year apprenticeship, which some duration, it took 12 years to complete my apprenticeship. So I turned out in 2002 as a journeyman, May of 2002.
How many years have you been working at IBEW as an electrician when you accumulated that pension?
You do not work directly for IBW. It's the International Brotherhood local union. You work for individual contractors.
How many years do you work as an electrician?
During my entire time, through my apprenticeship and my years of journeyman. So as a journeyman from June of 2002 to November of 2005 is my completion period of working as a journeyman. And then,
sir, that was not the question. How many years, not which different jobs, have you been working as an electrician?
Approximately, I would say, consistently, because there are gaps of unemployment. I'll say overall 8 years.
Okay, and what did you do before that?
Before I was an electrician, I was working for St. Luke's Hospital as a security officer and lab assistant.
Okay. And when you worked as an electrician, your first job in 2002, you earned approximately $26 an hour. I think the hearing officer said $25.90.
I believe that is some 25, yes.
Okay. And when you were working at Pro Electric, the most recent job on your financial information statement, how much were you earning per hour there?
Journeyman scale at that time, prior to me being laid off, was $30.73 an hour.
Okay. And after you were laid off from that job at Pro Electric, what job did you do after that?
I have not worked other than I relocated to Chicago in January of this year, January of 2007, and I obtained a job working for Burlington North Santa Fe as a maintenance electrician, and I worked there for 31 days prior to me.
And how much did you earn an hour at Burlington?
$21.87 was the journeyman scale for electrician.
Okay. And it's your testimony that you haven't worked then since 2005?
I haven't worked in the state of Missouri since 2005. I relocated to Chicago area, Country Club Hill, where I presently live, and obtained employment at Burlington North Santa Fe Railroad.
Okay. And is that where you still work?
No, I no longer work at Burlington North Santa Fe Railroad.
Okay.
I'm currently unemployed. I've been unemployed since April of 2007.
Okay. So up through April of 2007, you had a job as an electrician.
From February the 20th of 2007 through April the 22nd of 2007, I was employed as an electrician at Burlington North Santa Fe Railroad.
Okay. Have you joined your local union there in Chicago?
No. I initially joined and then they withdrew or denied my membership.
Why did they deny your membership in the electrical union?
I have no inside information as to the reasons why. I was just denied.
Why did you relocate from Kansas City, where you had several years of seniority as an electrician and were earning in the $30 per hour range?
Because the state of Missouri's Child Support Enforcement suspended my license as of June 29th of 2006. That prevented me from being able to make it to the job sites, construction sites. I did not have the ability to use automobile transportation to arrive to the various job sites, which made me have to relocate to obtain work elsewhere that would allow me to get to a stationary job.
Okay.
I became unable to work the construction industry due to the fact I didn't have my license was suspended for back child support.
Okay. So you had seniority at your union here. You were earning over $30 an hour at your most recent position, and instead of applying for the next job, as an electrician normally would do, you relocated because you had no driver's license.
That is correct.
All right. And you haven't joined your local union?
I was denied membership to the local union here in Chicago.
Okay. And if Pro Electric indicated that you were earning $37 an hour, that would be incorrect?
That would take in consideration the health and welfare benefits that is not paid on a check, but is paid into the benefits for your health welfare, your hospitalization, dental care that they pay on your behalf to maintain your health and welfare, or your medical and dental assistance for you and your children, or you and your family.
Okay.
That they pay while you're employed by them.
When you were earning $37 an hour, why didn't you pay
No, I was not earning $37 an hour on the paycheck. I was earning at $30.73 an hour per hour, and that was paid on the paycheck.
Okay. Why didn't you pay your child support so that you could keep your driver's license when you were earning that much?
I had been unemployed since December of 2005, and I was notified in January of 2007 that the state of Missouri's Child Support Enforcement was going to suspend my license.
Okay.
And
You didn't pay your support prior to 2005 either, did you?
Excuse me?
You didn't pay your support or your maintenance prior to 2005 either, did you?
Prior to 2005, I had garnishments that were being taken out of my check on a weekly basis that netted over $400 and some per week that were being paid. I've paid over $40,000 in child support over the last 5 years since this child support order has been in effect through garnished wages.
And that includes the amounts that they took out of the pensions and the quadro.
No, that's separate. That does not include the $30-some thousand in addition that they took from my 401k and annuity. That's separate from the $40,000 in garnished wages that they took.
And if you're not working as an electrician, what type of job have you been looking for since April?
I've been trying to obtain employment as an electrician here in the Chicago area.
Okay. And you stated that you believe that some of your children are emancipated, no longer in college or high school. Which one?
I know for a fact that my daughter has not attended high school. My twins.
Let's stop there. You're talking about Barbara.
Yes, my daughter Barbara, who is 21 years of age, birthday January 12, 1986.
All right. And do you know whether or not she's taken any college courses?
I know for a fact that she is not currently enrolled in any college or vocational school.
How do you know that?
Because I have not received any notification from her to that effect.
Okay.
She would be required to notify me.
She would be required in order to avoid an abatement, not for emancipation.
So I've spoken to her, and she was full-time employed last time I spoke to her, and was not attending any college.
Okay, and when was that?
That was it before. That was since I've relocated after January of this year. It was around February that she had plans of coming up here to visit me.
Okay. So you don't know whether or not she attended college prior to your discussion with her about college in February?
Yes, I've been in constant contact with my children. They would have told me I'll have direct numbers to all four of my children. I speak to them on numerous occasions.
Who does Barbara live with?
She is working and living with a roommate currently.
All right. Now, Duran and Dion, the twins, you said neither one of them is in school?
Duran McKenzie is scheduled to be taken into the Air Force the first of next month.
Okay.
And Dion is currently working 2 jobs, full-time, one and another part-time.
Who do they live with?
They live on, I believe, by themselves. Don't know since I don't live in Kansas City, I don't know their current living situation other than Duran is planning on leaving the 1st of August, and Dion is working. So I assume that if he's working, he's providing for himself.
Okay, and you didn't object to the entry of the Family Support Division's child status questionnaires on Duran or Dion that both stated they were still in school and living with their mother. Do you have any evidence to offer today that refutes those documents offered
Yes,
by the
that's
state?
correct. Yes, I do. My
Okay.
direct communication with
Okay, that I
children.
object to that as hearsay. Do you have
You asked the question.
documentary evidence?
Miss Hasenflow, you asked the question. Let him answer it.
My direct communication via telephone communication of each of my twin children, Dion and Duran, informing me that they were not enrolled in school and were one was planning on enrolling or enlisting in the Air Force, and the other one is working currently at Research Medical Center in Taco Bell.
And when did that conversation take place?
I just recently spoke with Dion back last month. So he was telling me he had just gotten a job working for Research Medical Center and was keeping his job working for Taco Bell.
And then your other child is still high school age and living with his mother. You don't have
No,
to dispute
no, I have knowledge to know that my youngest son, Michael E. McKenzie Jr., has been kicked out of his mother's residence.
Where does he live?
With a friend in Kansas City. With his friend's mother, who's allowed him to live with them.
Okay. And what's your current mailing address?
17963 Huntley. Huntley is spelled Huntleigh. Court, Unit 304, Country Club Hill, Illinois, 60478.
All right. I have no further questions.
All right. Mr. McKenzie, did you have any other testimony you wanted to offer this morning?
No, I do not.
Okay. I've got a few questions for you, and maybe just a couple, regarding Miss Gaston. You said you're looking for electrical work in Chicago area, is that
Yes,
right?
as of April the 9th, I was interviewed by Burlington North Santa Fe Railroad, attended orientation for a locomotive electrician position.
Okay. I'm sorry, what date was that?
July the 9th, I was extended an offer of orientation interview by Burlington North Santa Fe for a locomotive electrician position.
Okay. Have you heard anything back?
No, once I arrived at the location, because of my prior being employed by Burlington, you have to wait 6 months, which the day that I went there was the 6-month day when I originally was employed by as a suburban electrician. So I was within those 6-month period, so I became ineligible to re-interview and take the testing that was required to be re-employed by them.
For how long?
The next day, I became eligible again to be tested for that position.
Are you pursuing that?
Yes, I am. I have a position for electronic technician position that I had submitted at the same time for the position I interviewed, and I'm waiting for the testing for that to be scheduled.
All right. And so, is it looking promising?
Yes, it is. I have the credentials and the qualifications.
Okay. Any idea what your hourly rate will be there?
No, you're only told that after your extended position. I wasn't told my hourly rate when I was employed by Burlington. The hourly rate of $21.87 until after I was extended and actually employed. They disclosed the prevailing rate that you would be employed at.
Okay. All right. But you don't know, or do you know what the prevailing rate will be?
No, I don't know, because it's a non-union position. That the electronic technician it's not the same as a locomotive electrician. You're not. It's a different area. It's not it doesn't have a union.
Right. Well, Is that a position where you are actually on the train, or you are in one spot and you work on the trains as they come in?
Right. You work on the trains, communication. It's a communication position, working on end communication and front end communication equipment for the locomotives.
Well, again, my question, sir, was, do you travel with the train, or are you in one location?
No, you're in one location.
Okay.
You're in one location.
All right.
That as far as I'm aware of.
All right. Are you making any maintenance payments right now?
No, I don't have the financial ability. In fact, I'm 2 months currently behind on my rent here where I'm staying currently.
All right. Are you receiving any maintenance payments?
No, I'm not.
Are you making child support payments for anyone else?
No, I'm not.
And do you have any kids of your own living with you?
No, I do not.
All right. And I assume since you're not employed right now, you don't have any health insurance. Is that correct?
No, I do not.
All right. I believe that takes care of my questions. Ms. Hessenflow, any other questions for Mr.
No more.
All right. And just want to make sure I understand the testimony regarding the children. Mr. McKenzie, I believe your testimony was that Barbara's 21 now and not attending college.
Yes.
Duran is he already gone through basic training in the Air Force?
He's signed his paperwork. He's scheduled to leave. He's 19. The twins are 19. And like I said, he's planning on enlisting, leaving. He signed the paperwork, taking his physical, and scheduled to depart for training the 1st of next month.
All right. And you said Dion's working at Research Medical Center and Taco Bell.
Taco Bell, yes.
All right. And Michael is 17 and not living with his mother. Is that correct?
That is correct.
Okay. Is he attending high school?
Yes, he was when at the end of the school year. He was enrolled in high school. And I will be pursuing to make sure that he does stay and graduate.
All right. I believe that takes care of my questions. Ms. Hessenflow, anything else anything on behalf of your client at this time?
No.
All right, Mr. McKenzie, do you dispute any of the agency calculations regarding Ms. Gaston?
Yes, I believe in regards to her income or regards to my income for her payment for child support.
Well, child support, regarding the modification and the children named in that order, child support doesn't count as income to the custodial parent.
Okay, I believe that the incorrect number of right now, I believe that there are no dependent children that are being provided for by none of my dependent children are being provided for by their mother. My youngest child is no longer living in her residence, and that there are currently no children that are enrolled in any higher education or vocational school. Therefore, I believe that there is no requirement for me to provide any further child support payments to their mother for such care.
All right. Ms. Wilson-Hayes, anything else on behalf of the agency?
Oh, did we lose her?
I don't know, Ms. Hayes?
I said no, thank you.
Oh, I'm sorry, I didn't hear you.
I'm sorry.
No problem. Well, folks, what we're going to do now then is I'm going to have both sides making any closing statements that they'd like regarding this matter, other than discussing how long we're going to leave the hearing record open for. So that, Ms. Hessenflow, if you have anything else, please go ahead.
Nothing that I haven't already placed in the record.
All right. Mr. McKenzie, anything else, sir?
No, I guess I would close out to state also I still retain that I feel that the initial establishment order I was denied due process of law because it was not properly served on me at the time of it being entered. My residence and mailing address is 8609 East 87th Street, Raytown, Missouri 64138. and I was not served there, and all 4 children resided with me along with their mother at the time of the entry of the original establishment on July the 10th, 2002.
All right. Anything else, sir?
No, that's it.
All right. Ms. Hessenflow, how long do you think it'd take you, if there is a consolidation order in place, to give me a copy of it?
Well, when I call over, she's probably going to issue one if she realizes at the administrative hearing. It would not be normal for Judge Sil Rogers to issue an order of consolidation before both parties have been served and the case management. But by setting a case management, she is assuming jurisdiction and scheduling it for a hearing. The first one, I didn't address the consolidation because Mr. McKenzie has not been served. So I do not believe she has issued any written order, but I believe that she has assumed jurisdiction over the case by scheduling it, issuing a summons package to Mr. McKenzie, and trying to schedule court dates in circuit court. I will call over there and explain that the hearing went forward today and ask the judge's clerk whether the judge prefers that I just wait on the decision and then address the consolidation of a motion for judicial review, or if she wants to go ahead and issue a written order, which is what I can tell her you are requiring. So that will be entirely up to the judge. If she decides to go ahead and do a written order now, I will certainly send you a copy. If she says no, go ahead and let him issue his findings of fact and conclusions of law, then file your judicial review, and we'll consolidate it then that's what I'll do.
All right. How much time will you need either way?
I'll check on it this week without right away, today or tomorrow. It depends on how quickly the judge's clerk is able to get back to me and let me know what the judge prefers.
All right. Well, we'll go ahead and solve by Friday, Ms. Hessenflow. You'll be able to give me something one way or the other.
I would hope so, as long as the clerk is able to get back to me right away, and I can even just call and say, she says, just wait until he's been served and do the judicial review, or no, I intend to deal with everything, I'll send a written order. I can call and let you know what she prefers to do.
Well, whatever you do, I appreciate something in writing.
All right.
And that way I can send a copy to Mr. McKenzie too, so that he knows what's going on as well. So I'll give you till close of business on July 20th to do that. Can I go ahead and give you my fax number at this time?
Yes, please.
All right. It's Mike Dyer, D-Y-E-R, 573-522.
Oh, boy.
1366.
Okay, I didn't have a pen. Could I have your fax?
Sure.
Well,
573.
573.
522.
522.
1366.
1366. Okay.
And do you all want my mailing address as well?
I've got that on the notice.
All right.
I'll take it.
Okay, it's, again, my attention, DSS/DLS.
Okay.
P.O. Box 1527.
Okay.
Jefferson City, Missouri. And the zip code is 65102.
Okay.
All right. So I will wait till July 20th to see what we hear from Ms. Hessenflow, and then if the court does not consolidate the matter, then I'll go ahead and issue a decision based on what's been presented this morning.
All right, thank you.
Thank you all, and I wish you all a good day.
Thank you.
Thank you.
Thank you.